How are you? Hope you guys are doing amazing. Yeah. So what are we gonna see? So first we will revise. We will revise what section 4 talks about. So it talks about memorandum of association. What does mean memorandum of association? What and all will be there? One, what is the name? What will be the name of the company that will be mentioned in the memorandum of association? So if it is a private company, the last word will be private limited. But if it is a public company, the last word would be limited. But in case if it is a government company, so it can be either a private company or a public company. It will be the last word will be only limited. The last word will be only limited, but you have used. But if you want to have the last word to be limited, the financial statements should be filed, the annual return should be filed. But in case if it is a Section 8 company, you don't have to have the last word limited, or you will not have the last word private limited also. But sir, the next what will be the mention, sir? Next is where the registered office situated. You have to mention in which state of the country, the registered office of the company is situated. Next, object clause. What is object clause, sir? So, why companies incorporated? What is the business the company is doing? That you will mention. And along with it, there are few other things. For me to carry on my business, there are few other things I am doing. That also I will mention in the memorandum. Then next, what you will mention, sir? What is the member's liability? Whether it is limited or whether it is unlimited, that you will mention. But in case if it is limited, it is whether it is company limited by shares or whether it is company limited by guarantee. So what is the liability of in case company limited by shares? The members liability is up to how much shares amount is unpaid. How about companies guarantee? So in case of guarantee, they would have given what? Wow, they would have mentioned how much amount they will contribute at the time of winding up. Okay, this amount they will at the company being incorporated at that time itself they will mention. Yeah. So members liability arise. When will arise? In case of company limited by guarantee, in case of wound up. But if company ceases to be, if the member ceases to be the member, if the member if a person ceases to be the member, then what? Within 1 year. So within 1 year, the member has to pay the amount of liability, but you don't have to give more than how much you have told that you contribute at the time of winding up. What is the expense? Then rate of contribution among members have been adjusted. This I told you. Among members, the amount will be adjusted. Next, what will be there, sir? The memorandum will also mention some capital clause about share capital, amount of share capital registered, which is what is the authorized share capital, then number of shares and nominal value. There, so there, the about this is with respect to subscribers. This is with respect to subscribers. So yes or no? Yes. Then subscribers. So subscribers number of shares, how much they have agreed, but subscribers should at least have one share. Subscribers should have at least one share. In the memorandum, in the name of the company nearby that how many number of shares he has taken, that will be mentioned. Then in case of a one person company, in case of a company which is a one person company, where a person has died, who died, the member has died, then in case there's only one member there, then the member has died, instead of who will be the member, that member's name will be mentioned in there. Okay. And so name of the company. So what will can I have same name of other companies? If Reliance Industry Limited, can I have a name of Reliance Industries Limited? No. Can I a company's name is Wipro. Can I write Wipro E last? I'm mentioning E because of does it resemble? Yes, it resembles. But can I do that? No. Sir, I should not also have any name where it is as per any law. As per any law, it is an offense. As per any law, if it is an offense, and should not be. It should be desirable. It should not be undesirable. And so whether I'm keeping the name, where I'm keeping the name of what of a company I should not what I should not have same name. I should not or a name should not resemble of other company. Whether you have registered after this Companies Act 2013 or previous company law, which is after Companies Act 1956, you have registered. Either of this you have to comply with this. What other company's name you cannot keep it as your company's name. Company shall not register a name. Company shall not register a name. What? Where where it is giving an impression. Where it is giving an impression that because you're keeping a name of a company, public is thinking that public gets an impression that this company belongs to CG, SD or local authority, or where it has been where there are few corporations or body corporate which has been constituted by CG or SD, or it is public has an impression that this is CG's or SD's company. So the like that you should not keep, and there are few rules that you should keep in mind before making before complying. Company makes application to registrar. Company makes application to registrar for reservation of name. For reservation of name. Okay. For company proposed to be incorporated by an by an existing company for change of name. So if I want to start a new company, at that time I will go to the register and I will say reserve a name, some Ram Limited, Raju Limited. Okay, I will reserve, or already I'm existing, which means I already have a name. I want to change the name. I will go and I will reserve the name. Why am I reserving name? So today I thought enough of idea of Ramu Limited. Same one person, other person also thought of a word of a name Ramu Limited. Is it possible? Yes. Who will have this name? First, who goes and tells to the registrar that I want this name? He will only have that name. Okay, registrar may reserve the name. Registrar may reserve the name on the basis of the following documents furnished. What is it? Sir, in case of a company, in case of a new company where a company is to be formed within 20 days, name would be reserved for the company. But in case of case of a already company, if the company wants to change the name within 60 days, why 60 days? Because you have to pass special resolution and all for the 60 days. Ordinary or as a registrar has found after the name has been reversed that applicant has furnished wrong or incorrect information. What is this? So you are going to reserve the name. For that you will give some information to the registrar. Yes, I give an information to the registrar. That information is wrong. In that case, there are two cases. What is the first case where company has given a name but it has not been incorporated. In that case, the name will be cancelled, and who gave the application for him penalty is 1 lakh. And if company has not been incorporated, registrar will ask the reason. The registrar will ask the reason. Registrar will give an opportunity of being heard. Then registrar, after considering what the company says, registrar will say, okay, pass a special resolution. Then within passing special resolution, you have to within 3 months, you have to change the name. That the registrar will say, or registrar will say, strike the name of the company. Strike the name of the company. Registrar will say, or and how we will strike? There is a register. There is a register. In the register, registrar will say, or go for winding. Registrar will close the company. He will petition. He will go give a petition and close the company. So when will we learn this binding up? This is in CA final, not for you. So memorandum that in schedule 1, in memorandum you will have you are having 5 schedule. From this 5 you are having one schedule 1, there are 5 tables. From this you will select one. Why are we selecting one? If company is limited by shares, you will select table A. If company is limited by guarantee, you will select table B or table C. If company is limited by and company is unlimited company, then you select table D and table E, table D or table E. Sir, okay, sir. Okay. Rectification of name of company. Rectification of name of company. First situation. CG may direct the company to rectify its name. What in case of newly incorporated company or in case of existing company? Yeah, why CG is telling to change its name to because your name is identical or too resembling the another company's name. So company will change its name. When your company will change its name within 3 months of directions given by CG. How will it change its name? By passing a special resolution. Yes. Proprietor of registered trademark. Proprietor of registered trademark makes an application to CG. What? See, then a company has kept my name of trademark. Company is having my name, my trademark's name, which is similar or which is identical. Then what it has to do within 3 years? Within 3 years, it has to make an application to the CG. CG in the and CG is of opinion that yes, the name is identical, and CG tells the company to change the name. Company has to what? Company has to change the name. Yes, within 3 months of direction. Yes, by passing an ordinary resolution. Yes. Company defaults, what will happen? CG will allot a new name. CG will allot a new name. And CG doesn't want what? CG will not ask you what name do you want. CG will keep any name. And registrar will enter the new name. Say registrar will enter the new name with the register and issue a fresh certificate of incorporation. Issue a fresh certificate of incorporation. Section 16 says subsection 3 shall not prevent company from subsequently changing its name. Prevent company from subsequently changing its name. Yes or no? Yes. Company file with the registrar. Company file with the registrar within 15 days of passing ordinary resolution. Notice of change. A copy of order of CG. Registrar shall make necessary changes in the memorandum certificate of incorporation. Yes or no? Yes. Yeah, first we'll devise alteration of memorandum. Yeah, good. So, if you want to alter the memorandum, what you have to do? You have to pass a special resolution. Along with you have to comply what section 13 talks about. So capital clause we'll see what when we study section 61. Yes, yes. So if you want to alter the name clause, company will change its name. Company will change its name when a special resolution has been passed. Along with it, your company has to give an application to CG in form INC 24. Why we are giving a form? Why we are giving an application to CG? Because we need approval of CG, and CG will approve in writing. Yes or no? Yes, and company will file with the register. What will company file? Company will file a copy of special resolution passed, and company will file that CG's orders has been given. Yes or no? Yes. And register, what will he do? Register will enter in the register. What is the name of the company? And he will issue a fresh certificate of incorporation. And this will be mentioned in form INC 25. Yes or no? Yes. Change shall be complete and effective. When will, sir, I did all this. In which process I can say that, when which process I can say that my name is completed. Okay, now then this is my new name. When the process completed, only when certificate of incorporation is received from the registrar. Sir, if I want to convert from public to private, so my name will also change. So in that case, should I get the approval of CG? No, not required. Sir, what if I have defaulted in two things. One, I have defaulted either in filing the financial statements and annual returns with the registrar, or I have defaulted the repayment of deposits, debentures, and interest. What if I have done this? In either of this, if I have done it, then I cannot change the name. Then I cannot change the name. Yes or no? Yes. So if there is no default, then you can change the name. Sir, I'm altering the situation clause, which is I'm altering the registered office from one state to another state. In that situation, what should I do, sir? I have to pass special resolution. I have to get the approval of CG. Then what, sir? Then I will make an application to the CG. For me to get an approval of CG, I'll make an application to CG, and CG will dispose of this application within 60 days. And before CG disposing of, he will consider few things. CG before disposing, CG before approving the application, CG will do what? CG will see few things. What are those few things? He will see whether consent has been given by creditors, debenture holders, or other concerned person. Also, he will see whether the company has made provision in discharging the liabilities. If not, whether that if not adequate security has been given. So either of these has been fulfilled. If none of this is fulfilled, CG will not give an approval. Yes or no? Yes. Company will file with the registrar what? The copy of special resolution, and an order has been given by CG. If that has been given, then what? If that has been given, then what? Registrar shall register order of CG and issue fresh certificate of incorporation. Yes or no? And where the certificate has been given, then where the certificate, what certificate, sir? Or registration about certificate of incorporation, then it is deemed as effective. It will be deemed as so no. So, yes. Yeah. So what are we gonna see? First we will revise registered office. Every company should it have a registered office? Yes, it should have a registered office. It should have a registered office within 30 days of incorporation. Yes. And a company also should do verification. Yes, company should furnish register so that so the verification can be done. So company should tell furnish to the registrar so that verification can be done. This will be done in Form INC 22. Yes. Such registered office. So why do we need registered office? For that, so that we can receive or we can acknowledge. We can receive or we can acknowledge few all notices and communication. Yes or no? Company is not some call where they can get all the information through call. Of course, they will, all those communications should be received through what notices and all, right? Yes. Every change in the situation, every change in the registered office, what you have to give. Notice shall be given. So notice shall be filed with ROC. Notice shall be filed with ROC within 30 days. Yes or no? Yes. And ROC will record the this change. Yeah. No. This is more important. I thought of skipping this this particular this. I thought that you guys already knew, but I thought that I just want to again do this. So one registered office to another, one registered office to another registered office, same city, town, and village. Pass a board resolution. Pass a because company has to decide who can one director decide. Of course, board resolution is important, but then inform it to ROC. Yes or no? Yes. So no. Now only play changes. So same state, one city, town or village to another city, town or village, same jurisdiction of ROC, then special resolution to be passed. Then you have to file with ROC. You have to file with ROC. What? One you will file special resolution. This will be in form MGT4. Then you will file notice that for the change. And this will be form INC 22. Yes. Now, situation 3. Situation is where same state same state and jurisdiction is of another ROC. From there is different ROC. From one city, town, village to another city, town, village. Different ROC. In that case, what to do? Of course, special resolution to be passed, and you have to obtain the confirmation of regional director. Yes. Okay. For obtaining the confirmation of regional director, what you have to do? You have to make an application in form INC 23, and you have to also, along with the application, you have to give some documents. What are those documents? Board resolution, special resolution, where declaration is given by whom two person can give. It can either be given by key managerial person or board will authorize two person. Board will authorize two person. Those two person will be directors. So two directors. They will tell that we have not defaulted in the workman. We have not defaulted in the workman. Yes, yes. And consent also will be obtained from the creditors. Consent also will be obtained from the creditors, and a declaration will be given that yes, we are saying that we want our registered office from one place to another place. But if our cases is pending, if there is a case pending, if there is a case pending, we will not ask that to be changed from one place to another. That will keep on going. So that will a declaration will be given. Copy of acknowledgement, what that we are shifting, that will be sent to the chief secretary of the state, and also that employees will not be adversely affected, will not get affected because of this change of registered office. This will be mentioned. After examining application, who will give order? Of course, the regional director only. Because we are giving application to regional director will pass order. What either he will approve or reject it, but he will do within 15 days. Within 15 days of receipt of application, company files it. Company files with whom ROC. When company will file it, when region director approves it. If region director doesn't approve, why do you want to file? Of course, you don't have to file. And then you will file in form INC 28 within 30 days of receipt of certified copy of order, and along with it, you will give fee. Company shall mention few things. Company shall mention few things. What are those things? What are those things? Superb. First, yeah, what name and address of the registered office you have to mention in every office and every place in which business is carried on. Yes, and it should be legible letters. It should be in a conspicuous. It should be in a conspicuous position. And characters are of language in general use. Then they use that. I use that. Yes. So if it is if the characters are of language, if the language in general use in that locality, what they speak in that locality, even mention that language. Companies. Oh God, this word. Company's name. That is the main word. I forgot that. Company's name shall be engraved in legible characters on common seal. Central government may notify any other document on which name of company is printed. Yes or no? Yes. Company will print on business letter, billheads, notices, and official publications. What containing following matters? What are those? Name, address, telephone number, fax, mail, website, SIN. Yes, fax and website, if there is there, then you have to mention. So company may have if company is having a website, whether there is online business going in website or there is no online business going in a website. You have to mention all these details. What name, address, telephone number, fax, email address. Yes, SIN plus along with it you will also mention the name and phone number of a person or to whom you can call and ask make some doubts. Yes, like this we did some studies. Like this we did some studies. Yes or no? Yes. We are going to see section 5. We are going to see section 5 alteration. We'll see that revision. Alteration of a company. Alteration of a company shall contain. What does it contain? Not alteration articles. The how to regulate a management. It will contain that. Can it include some additional matters? Can it include some additional matters? Yes. And so what is provision for entrenchment? What is provision for entrenchment? If there is some specified provisions, if there is some specified provisions of the articles, that there is if there is some specified provisions in the articles, okay, which is more restrictive, which is more restrictive than special resolution. which is more which is more restrictive than special resolution. That is what is provision for infringement, and this can be done by how. If it is a private company, all members should agree. Then only it can be more restrictive. If it is a public company, then you have to pass special resolution. Either on formation or after company being formed. What you can do this. Company shall give notice to the registrar at the time of incorporation. If it is an existing company, form number MGT 14, and it should be given within 30 days. Specified provisions that are more restrictive is called as provision for enlargement. In Schedule 1, Table F, G, H, I, J will contain few things. If it is F, company limited by shares. If it is G and H, it is company limited by guarantee. If it is I and J, it is an unlimited company. So you have to see which company you are, and you have to include that in your articles. Yes or no? Company may opt. Company may opt what? Company may opt the model articles. Yeah. So either it may include, it may add, it may entirely include model articles or few provisions of the model articles. Sometimes company will not exclude or company will not modify what any provision in the model articles. It will as it is copy paste. If that is so, then the articles should comply with model articles. Then the registered articles, what and all provision model articles in registered articles should comply. This section shall not apply to who? Sir, if it is a Companies Act 2015, which is registered under previous law, then you have to do what? You have to change it, you have to amend it, and you have to go according to Companies Act 2013. Memorandum and articles, who will sign it? Each subscriber will sign it. And the subscriber will contain what? His name, his address, and his occupation. And a witness will be there. In the presence of, while the subscriber is signing, the witness, at least one witness will be there, and he will sign, and he will also add his name, address, and occupation. Yes. Where a subscriber is illiterate, what to do? A person shall read for the subscriber. He will explain he will read and he explain what and all is there in memorandum and articles of association. He will do. He will write the name. He will write the name of the subscriber. He will mention how many number of shares are you holding. And the illiterate will put his thumb impression, and the person will write below or against the thumb impression what his name, whose name, illiterate's name. Then he will authenticate his signature. The person who will authenticate his signature. Yes or no? Yes. Particulars of subscribers and witnesses shall allow typewritten or printed form, so long as they append their sign or thumb impression. Yes or no? Yes. So can I ask you a question? Simple question, which I didn't include in this notes. What is it? Simple. Can a person who helped the illiterate, can he be a subscriber? Superb. No, he can't be a subscriber. So if he is a subscriber, he can't be the person who is helping the another subscriber. Yes or no? Yes. You will. So what are we gonna see, sir? So we did 3 sections. Yes. So I thought that we just revise those 3 sections today. So what did one section we saw? We saw alteration of articles. What is alteration of articles telling us? That if you want to, first a company wishes that they want to alter the articles. So at that time, what company should do? Company will alter, but company will keep in mind something. So what will company do? They will knock their head and ask, what should I keep in mind? I should keep in mind 2 things. What is it? When you alter the articles, still you have to comply Companies Act 2013. You have to comply memorandum. You can't go against Companies Act and you can't go against memorandum. Every alteration of its articles is subject to provision contained in this act in the memorandum. Okay. So now, if you want to alter, okay, I kept in mind what that I should not go against those memorandum and companies act. Okay, I want to change the article. So what should I do? Pass a special resolution. Pass a special resolution. File with the company. File with the company. File with registrar. File with registrar. And when I have to file, I have to file within 15 days. I have to file within 15 days. And registrar will register it. And registrar will register it. Yes, this is how generally we have to do the alteration. But if it is a conversion from private to public company, it is a conversion from private to public company, what to do? First pass a special resolution. First pass a special resolution. Then in the articles, you don't have to include one, you don't have to include a thing. What you no longer need to include in the articles, the restrictions, what restrictions. So one is, so can we revise again, please? Members maximum 200. Next is your members want to transfer, they say there's a restriction. Third is if off or we what prohibited, what is prohibited, offering our securities to the public. Yes, these three are prohibited in case of private. Now because we are converted to public, we no longer need that. Yes or no? We no longer need those three restrictions in the articles. Okay. So I so now I alter the articles. Can I say now it is now I am a public company? Yes. So conversion shall take effect. Now because conversion is taking from private to public, it is taking effect. But taking effect from when? From when I alter the articles. Then what I have to do? Again, I have to file with the registrar within 15 days, and the registrar will register the same. Registrar will register the same. Yes or no? Yes. Next. Now what I want to do? I want to convert from public to private. I want to convert from public to private. What I have to do, sir? Super. I have to pass a special resolution. Next, what I have to do? So now, because now it is a private company. In the articles, we have to include that restriction. Yes or no? What restriction? Three restrictions. 200. The transfer restriction and the prohibition in for issue of securities. Yes, to the public. So that will be included, because while we are converting from yes. Obtain the approval of CG. Now we are what obtain why we are obtaining the approval of CG, because now we first it was a public company. First it was a public company, and we had what we had the approval of CG. So we had public money. So the safeguard, we should take the approval of CG. Now because we want to take the approval of CG, what company have to do? Company has to give an application to the CG. Then, okay, sir, when is alteration conclusive? When I can say I got converted into public company? Can I say after changing the articles, can I say that I got converted? No. Then only when you get the approval of CG. Only when after you get the approval of CG, only you can say that you got altered. Now, so company files with the registrar. Company will file with the registrar what? Within 15 days, two things. First, we always say that altered articles, but this time there is an approval of CG, so that also will be filed. That copy also will be filed. What are we gonna see, sir? Section 7 Incorporation of Company. Section 7 Incorporation of Company. So company will file to the registrar. Which registrar? To the registrar where the company is going to situate its registered office. In that place where the registrar is there, that registrar, to that registrar, company is gonna file what few documents and information. Why company is gonna file few documents and information? So that registrar can register it. So because why? What if registrar registers these documents? Then company will get certificate of incorporation. Company will get certificate of incorporation. So what and all documents and information company has to give to the registrar? Memorandum articles. One is memorandum and next is articles. A declaration shall be given. A declaration shall be given in form number INC 8. Form number INC 8. So who will give the declaration, sir? An advocate will give a declaration. A chartered accountant will give a declaration, a cost accountant will give a declaration, and company secretary. All these who are doing in practice will give a declaration. Why are they giving the declaration? So because they helped in the formation of the company. They were helping in the company's formation. Yes. Also in the articles, whose and all names were assigned as directors, managers, and secretary. They also will give a declaration. So what declaration will they be giving, sir? That for registration, with respect to registration, company has complied Companies Act 2013 and its company's rules, whether they have complied it or not. That has to be given as a declaration. Next, a declaration in form number INC 9. Form number INC 9. What is this form number INC 9, sir? That first, before what is it? Who will give the declaration? Who will give the declaration? Two sets of people will give a declaration. One is subscribers. Every subscriber to the memorandum will give a declaration. And next is first directors. First directors will give a declaration. Yes. Okay. Okay, sir. So in the declaration, what will be mentioned? With respect to promotion, with respect to formation, and with respect to management of any company, there has been any offense, then whether they have been convicted or not. So he should give a declaration, no, he has not been convicted. He has not been convicted for promotion, formation, and management of any company. Next, that he is not guilty of any. He is not guilty. He is not found guilty. He is not found guilty. Yeah, maybe he would be guilty, but actually he is not caught yet. He is not caught. Okay. So guilty of any fraud, misfeasance, or breach of duty. Not for the entire life during the preceding 5 years. During the preceding 5 years. Next. So what and all documents and what and all information a company has given to the registrar for registration purpose, whether he should give a declaration that it is correct. He should say that it is complete. It is not incomplete. It's not incomplete. It is incomplete. And to his best of his knowledge and belief, the information and document given are true. Next. Sir, registered office will be will be done within 30 days. But before that, for example, 25th day they have done, they have made it. But when will companies wants to, if any person wants to give company any communication or any notices, so for them to give that communication and any notices, give an address till that. Okay. So the address. Next, subscriber will give following particulars. So subscribers will give following particulars. What are the particulars? So in case of a body corporate, central government will say what and all are the particulars. But in case of an individual, name, surname, residential address, nationality, proof of identity and proof of residence. Proof of identity and proof of residence will be given. Yes or no? Yes. Subscriber is holding DIN. Then proof of identity and proof of residence is not required. Not required to be attached. Yes or no? Yes. So what and next? In case of first directors, what will they give? So they will give the name, they will give their surname, they will give their family name, residential address, nationality, DIN, director identification number, proof of identity, or what and all CG prescribes to give those information will be given. And they will also give that yes, I'm in interest to work as a first director in this company. He has to give his consent. Then he has to also disclose. That whether he's having any interest in other firms or other body corporate. He is having any interest in other firms or other body corporate. Registrar, after receiving that, registrar where all the documents and information have been filed, registrar shall register what the company, and a registrar will issue a certificate of incorporation. So the certificate of incorporation is form number INC 11. Form number INC 11. So in certificate of incorporation, they will mention corporate identity number. Corporate identity number 6. Sir, DIN. DIN means director identification number. Okay. So where you don't confuse SIN and DIN. First, DIN is for director, SIN is for company. DIN, where DIN I stands for identification, but where I stands for identity. Okay. So every company will have will be getting a different SIN number. It won't be like same number. It will be different. So it will be distinct. And the SIN will also be included in the corporate identity certificate of incorporation. So certificate of incorporation will also mention the date when the company got incorporated, also the name, also where income tax authority has given PAN, PAN, then even permanent account number also will be mentioned in SIN in the certificate. Yes. Sir, okay, sir. What and all company has filed with the registrar for registration? After registration, can I dispose of? No. Till the company gets into dissolution, till that it has to hold what all the documents which has filed with the registrar. Company, if in case company furnishes any false or incorrect particulars, then what to do, sir? Or suppress any material facts, then what to do? Those who are furnishing it, they will be liable under section 447, which is a fraud section. Where and also promoter, each person in the articles as first directors, each person made declaration that they have complied with. Who made the declaration? We already saw. Who, sir? Just think and tell me who gave the declaration. So this is a small test. We revised this point. Who gave? Yes, sir. CA, cost accountant, company secretary, advocate in practice, and director, manager, secretary. They have given, so they will be liable under section 447. Yes or no? Next, tribunal is satisfied. Tribunal is satisfied with what? That company has given false or incorrect information and all. They have tribunal is satisfied in that situation. It is warrant. The situation warrants what? To tribunal to pass an order. So in that case, tribunal will give what? Will say that regulation of management. Will give it what for regulating the management, what and all is necessary. Tribunal will pass such order, and keeping in mind public interest of the company, members interest, and creditors interest. Yes. Or make the members liability unlimited, or make the members liability unlimited, or remove remove the name of the company from the register. So this you'll be studying chapter 18 in CA final. There are only 5 sections, and yeah, this section always makes me happy. Like, it is interesting. Pass an order for winding up, and or whatever order CG deems fit, the CG will pass that. But before passing the order, tribunal will keep 3 things in mind. What? First, giving an opportunity to of being heard. So company will tell company why they did this. So keeping tribunal keep that in mind, that what and all, why did the company do that? After that, tribunal pass an order, or what and all are the transaction company has done. Keeping that in mind, that also in mind, tribunal pass an order. What and all are the liability? What and all are the payment pending? The company have to give to others. So that also keeping in mind, company will pass an order. So what are we gonna see? First, you revise section 10A commencement of business. Yeah. Company incorporated after commencement of Companies Amendment Act 2018. That is after 2nd November 2018. And company is having a share capital. Company is also having share capital. In that case, company will commence business or company will do company have the power to borrow only when two conditions are satisfied. What are those two conditions? First is a declaration will be filed. What is the declaration? First, this declaration should be in form number INC 20, yes or no. And what is the declaration? The declaration is respect to where the subscriber should a subscriber buy a share is he should at least own at least one share that we saw in the when we was learning about memorandum, yes or no. So within 180 days, how much ever shares he agreed to pay, how much ever shares he agreed to purchase, that means for that shares has he paid. So the declaration will be given by the director within 180 days. Within 180 days from date of incorporation. 180 days from date of incorporation, yes or no, yes. Then this declaration will be verified either by CA, CS or cost accountant in practice. So just see, sir. Just look at it. How much work we are getting. More than that, how much respect and how much belief we have. So why do a chart accountant or why do a company secretary or why do a cost accountant have to do this? Have to verify. The police can do it, an advocate can do it. No, a chartered accountant is doing it because the trust, the everything. Oh my God, chartered accountant is having so much power, brothers and sisters. The trust, the belief, everything is there. So yeah, so if you become an engineer or during the process of engineering, you'll be like, ah, if I go to a job or if I will I have any work? Will I have any respect after becoming an engineer? Yeah, people may think. And do you think that will engineer have respect? Will engineer have respect? Do you think that? Yes. If the engineer is successful, how an engineer if he's having a lot of knowledge. But do do chartered accountants think like that? No. Chartered, when will I become a CA? When will I become a CA? When will I be a CS? When will I be a cost accountant? That's what we guys think. Because after becoming that, we know that we will get work. So you place wherever you want, sir, in the city. You place wherever you want. What? An office. An office. Surrounding you, sir, individual whether individual if they have more than basic exemption limit, if their income is more than basic exemption limit, they have to come to you for what? For the tax filing. If they are not even gonna pay any tax, still they have to come. If those who are doing business, individual, they have to come. Those who are doing as company, firm, LLP, artificial judicial person, association of parties, both, every single body has to come. Every single body has to come to you to what? To get ordered, to do order if they are doing business. Oh my God, just think about it, sir. Verificate company has to do give how much time CAs and you keep on seeing how much time CAs will be there. Even in CA finance also you will see how much time chartered accountant will be. Lot of works we are getting, sir. So but still there are few brothers and sisters. There are few brothers and sisters who think, nah, I don't want to be because there are still few brothers and sisters who think that we need something else, we want to do something else. Then a lot of people have done UPSC. There's an UPSC brother who told that no, he's afraid to write. He cleared CA and he's afraid to write CA exam, but it's hard. It's hard. He cleared with good marks. He cleared. He got some all India rank from, I don't know, some 11th rank. It's amazing. It's amazing. CA is amazing. We get a high number of big respect. A very, very big respect. Yes, we do. We do. So I hope you guys study. We don't think why I said the year is we are not scared of whether we'll get work or not. We are only scared whether we will pass or not. Yes. We are not scared of whether we'll get 90%. A lot of people don't think of whether we'll get passed on. A lot of people, only very few people think that we want all in their rank holder. No. A lot of people think we want good marks or we want to pass. The end. Because those who are entering CA, most of them are like brilliant students. Brilliant, most of them. There are few brothers like me who are not brilliant, but most of them are brilliant. Okay, so I'm just telling the value of CA. There's no, I can't express the value of CA. It's like an unspoken rule. What you can't explain. It includes CA includes. CA doesn't. The value of CA includes. You can keep on including the value of CA. Point wise, point wise, point wise. Okay, coming back. So in this point, I forgot to write one thing about sectoral regulator. That provision I forgot to mention. The sectoral regulator is where if you like bank, if you want to start a bank and all, you have to get the approval of the RBA, and then along that you have to attach with this declaration. That you have to attach with this declaration. Yes or no? Yes. This is one condition. The second condition is you have to file with the registrar the verification office, registered office. If you do these two, then you can commence the business, or you can also start borrowing. Yes or no? Yes. If you have done default in this, company penalty is 50,000, office and default penalty is 1,000, maximum 1 lakh. And registrar, you can initiate removing the name from the register of companies. If within 180 days declaration has not been given, yes or no? Yes. Pre-incorporation contract. What is this contract made before or on? It's made on behalf of company before incorporation. By whom? By the promoter. So promoter, before the company got incorporated, he would have entered a contract. It's called pre-incorporation contract. How can that be? Incorporated? That contract, how can it be enforced? Section 15 and Section 19 of Specific Relief Act 1969 says that where pre-incorporation contract. Pre-incorporation contract is enforced by company and other party if following conditions are satisfied. What are the conditions? Contract is enforced for the purpose of the company. Contract is warranted by the terms of incorporation. What is the object? Is the contract as per the object of the company? Yes, we have to see that. And also the main important, the company is accepting. Company has to accept it. Company has to accept that the contract is okay, and company will communicate it to the other party. Yes, yes. Company prior to incorporation, can it ratify? No. But company after incorporation, can it ratify? Yes. Otherwise, promoter will be held responsible. What is this? So company enforced pre-incorporation contract. Then will promoter will be liable? No. Otherwise, promoter will be held responsible. Yes or no? Yes. Class got cut. So first we just revise section 3A. It will just take me only half a. Then we'll go with what we were discussing, what we were about to discuss last time. If at any time number of members is below a 7 or 3 in case of public or private company, the company carries on business for more than 7 years, more than 6 months, not 7 years, more than 6 months, then every remaining members who is cognizant means who is having knowledge of the fact that number of members has fallen below the statute limit shall be liable for any debt contracted after the period of 6 months and maybe severally liable be sued for therefore. Yes or no? Yes, sir. Today, what are we gonna see? We are gonna see a lovely thing called revision. I'm sorry, we are gonna do revise of section 8. I'm sorry, Malik. We are gonna see section 19 revision, and then we will look at the new section. Okay. So what? A company cannot hold shares of holding company either by itself or through nominees. And holding company cannot allot or transfer the shares of holding to subsidiary company. Okay, if allotment and transfer is made, then it will be considered as void. Next, but a subsidiary company can hold shares of holding company. What in the following cases? What are the cases? If deceased member of holding company assigned legal representatives as a subsidiary company, then subsidiary company also can hold shares by way of trustee. In these two cases, subsidiary company have the right to vote, and a subsidiary company can hold in another way also. For this, there is no right to vote. What is it? Subsidiary, before it became a subsidiary company, it was a shareholder. In that situation, they can hold. In case subsidiary company is a company limited by guarantee or unlimited company, we are talking the shares cannot be transferred, cannot be allotted. So in respect of shares, we will consider it as interest of its members, where there is no share capital. We will consider the interest of members. Section 8. Central government is satisfied. Central government is satisfied on the proof that a person is registered, a person is registered, a person is proposed to be registered, a person is proposed to be registered under Companies Act 2013. A person is proposed to be registered under Companies Act 2013 as a limited company. So the what a person is proposing to register in Companies Act as a limited company, yeah, and see, this satisfied what, that this limited company has in its objects, the limited company has in its objects promotion, of. So what do we study in what do we study? Commerce. We study something arts. We study science. So we study science, yes. Then we play sports. They tell us to play sports, and they tell us to what? Study education. Yeah. Yes. And big school what? They even do research. Research, RESEARC, research and religion. There, what lot of people, let's say there a lot of people are researching. The scientists are researching whether there is God, religion. Yes, there is God. I know that. I hope you also know that. There is social welfare. There is social welfare. Then there is protection of environment. Protects social welfare and protection of environment, such as some historical places. You are protecting. They're protecting the vertical place, or you are protecting the environment from global warming, such as like that. Then charity. Then any other such objects. Yes. Yeah. So the objects. These are the objects you are promoting. These are the objects company is promoting. Yes, Section 8 company is trying to promote. Next, CD is satisfied with that. Then next, CD is telling that, CD is saying that it intends to apply. It intends to apply the profits. It intends to apply the profits or any other income. It intends to apply the profits or any other income. What? To promote the objects. To promote the objects. For example, such as so what is the company's, what, let's say company's businesses giving education to the poor. Giving education is to the poor is what company is trying to do, yeah. So they don't have money, companies who are giving education to the poor. That is the object. That is what they are trying to promote, so that they can give a lot of facilities to those girls and to those boys who are poor and who is not unable to go to a private school or government school. They are giving this particular persons are trying to educate them. They are trying to educate them by giving them education. Yes. No, they will earn some profits. They will earn some profits or any other income from that. From that income, what they will do? Will they give dividend? No, they will again what? From 100 students, they will promote. They will promote, for example, 150 to 200 students. Yes, they will promote. They will promote. Yeah, they will promote the objects. They will promote the objects. So the object is educating the poor who is unable to go to school. So from 100 students, they are promoting the objects. They are from 100 students, they are going to 150 students. Next, intends to prohibit to di- to give dividend to give dividend to any member to give dividend to any member. Yes. So CG is satisfied. CG is satisfied. What CG is satisfied? So what is CG satisfied? A limited company, a company where a company is going to get incorporated. A company is going to get incorporated and their objects. What are the objects? What are the objects? Company is going to be get incorporated as a limited company, and their object is either commerce, art, science, or sports education, or research and religion, or social welfare or protection of environment, or charity or other such objects. So why I gave this away is easy to remember. Commerce, art, science. You can study the school. In school, you would have studied either commerce or science. Sports and education. That's what in school we do. We either do education or we play. Research and religion. A lot of people do the research. Scientists do research with respect to religion, social welfare and protection of environment, charity and other objects. Yes, these are the objects what this company is trying to promote, and whatever profits or whatever other income they have earned, what that will be again inserted to the promoting the objects, and no dividend, because dividend is prohibited. This particular thing, CG is satisfied. CG is satisfied. This is what the company is going to do. This is what the company is going to do. Yeah. So after CG being satisfied, CG will do what? After CG being satisfied, CG may issue license, and provide provide conditions to be followed as CG may deem fit. As CG may deem fit. CG will first issue license. Yes. So a Section 8 company should have a license. Section 8 company should have a license. And CG will what if they wish, they will also prescribe some conditions. Yes. Yes. And allow such company to be registered. Allow such company to be registered under Section 8. And what allow such company to be registered under Section 8 and without including the words limited or private limited in its name. In its name. Sir. Yes. So till now, what did we study? Till now, what did we study? The central government is satisfied that a limited company, a company which is going to be a limited company, its object is in promoting commerce, sports, research, social welfare, charity, and related to that. Yeah, and it intends to apply profit or other income only to the promote these objects, and it is intending to prohibit. It is intending to prohibit dividend to members. It is intending to prohibit to give dividend to the members. Yes, and CG may issue license and provide CG may issue license and CG may provide conditions to be followed. Yes, CG may say that these are the following conditions you have to follow. Yeah, they say that it's not mandatory. If CG thinks, CG will give conditions. Then CG will allow it to be registered under Section 8, and it doesn't have to include the word private or limited or private limited or limited in its name. Next, no. Now what first we'll write alteration. Alteration of memorandum of association or article of association. Yes. So I'm so sorry with my handwriting. I always say I'm so because I'm not a multitasking person. I can't concentrate with my handwriting. I can't think of what and all points I have to teach you, and I am unable to do all those. Yeah. So and this writing part, see, first of all, generally my handwriting is not that great. Normally, for it, I have to put all my efforts if my handwriting should be good. I have to concentrate on that. Yes. So alteration of MOA, how does it happen? How does it happen? Company which is registered under Section 8. Company which is registered under Section 8 may alter its MOA or AOA when on approval from CG. On approval received from CG. Next, conversion from Section 8 company to other company. How will you do it? How will you do this? It's very easy. What is it? As per Rule 21, special resolution shall be passed for the conversion. Then only this will get converted. So what about conversion of a limited company to a Section 8 company? How about this point? How about this point? So how this happens? Company. So how does this happen? Where CG is satisfied. What CG satisfied? What CG satisfied? That all conditions is fulfilled. CG satisfied that all condition is fulfilled for it to be a Section 8 company. What are those conditions? Which is mentioned in Section 8, subsection 1, clause A, clause B, and clause C. Yeah. This guy CG satisfied. Then CG will do what? CG may issue license. CG may issue license plus provide. CG may issue license plus provide conditions. Provide conditions as it may deem fit. Which is to be followed as it may deem fit. Next what? CG may allow company to register under section 8. Next, CG may tell the change its name by omitting the words either limited or private limited. You have to, as the case may be. Yeah. So this is the situation. Yes. Now, whether first time you are incorporating or you are converting to a section 8 company, registrar shall registrar shall register on an application made to him. Yes, registrar has to register. Next. Now what are we going to see? Now we saw revocation of license. So what is it, sir? What are the points? First one, what is the first point? First is right. CG may revoke license. CG may revoke license when? If CG may revoke license if company contravenes section 8. Section 8 company contravenes section 8. Yes. Next. Section 8 company, what they do? What they contravene? They contravene the conditions while giving conditions to be satisfied, conditions to be followed while giving or while issuing the license. Next point. There are 3 points in this next point. First, what is this? First is affairs of the company. Affairs of the company, what? Are conducted fraudulently. So what is this affairs, sir? Don't think money. We are talking about the management. Affairs are conducting not only money, even everything. The management is conducting the business fraudulently, managing business fraudulently. Means violating the objects. They told that they will do charity, but they are not doing charity. They are violating the objects. Or next point. Which is prejudicial, anything which is prejudicial, which is negatively affecting the interest of the public interest, which is negatively affecting the public interest. In this case, CG may revoke license. Yes. And what? CG will revoke and CG will give order. CG also will give order. What? Directing company to change the status. After that, what they will order? They will change its name. How will they change its name? How will they change company name? By adding either limited or private limited. Yes, sir. Yes. Note. I'll give a note. Before making revocation order, reasonable opportunity for being heard shall be given to the company. Yes. Yes. And this is first note, second note. Company files order of CG to registrar for registration. Sir. Location now we have to do. Okay. After revocation, we have to do this from this. After revocation of license, what will happen? Central government is satisfied. Central government is satisfied. What? For central government may by order. Central government may by order. What? By satisfaction is satisfied in public interest. In public interest, either to wound up the company, either to do winding up, close the company, or to amalgamate with other company having similar objects. Yes. Yes. Note. Before making order, a reasonable opportunity should be given to the company. Reasonable opportunity of being heard should be given to the company. Yes. Next is after, in case of winding up, after debts and liabilities satisfied, satisfied, any asset remains. Then what to do? Any asset remains, then what to do? Think and tell me. We just saw, sir, any asset remains, then what to do? This asset will either be transferred. This asset, after all the debts and liabilities, this assets will either be transferred to some other company who is having similar objects, or the asset will be sold and the proceed will be transferred to investor education fund I'm sorry, not investor education fund, I'm so sorry. Insolvency and bankruptcy fund, which is mentioned under section 224 of IBC 2016. Yes. One last point. Where section 8 has been contravened. Then what is the punishment? Company minimum 10 lakhs, maximum 1 crore. Director and officer in default. Minimum how much? 25,000, maximum 25 lakhs. And if there is the affairs of company, if that has been done fraudulently, then the officer in default liable under section 447. Yes or no? Yes. So what did we see in section 8? We'll revise and that's it over, sir. That's it over. We completed section 8. So CG is satisfied. CG is satisfied, and what? That the company which is going to be incorporated as a limited company, its object is to do promotion of commerce, sports, research, social welfare, or charity, and it is intending to apply the profits only for the promotion of these objects, and it is prohibiting giving dividend. If CG is satisfied this CG will do what? CG will issue license. CG will issue license and provide condition which is to be followed. Allow such allow, and CG will also allow to be registered under Section 8. So it will be considered as Section 8 company. You don't have to include the word in your name, in your company's name as limited or private limited. If you want to alter MOA, you have to get the approval of CG. If you want to convert from Section 8 company to other company, a special resolution is required. From where you want to convert from limited company to Section 8 company, CG should satisfy all these conditions. Section 8, subsection 1, A, B, C, and CG should, will give license, allowing you to register under Section 8. Will tell you to what? You can change your name, omitting the word limited or private limited. Yes. And registrar will register by making an application to the register. Registrar will register by making an application to him. Yeah. And when will CG revoke the license? When you contravene Section 8 or you contravene the condition given by CG, or you may where the affairs has been done fraudulently, or you have violated the objects, or judicial to the public interest. Then CG will direct company to change the status from Section 8 company to limited company, and change also the name by adding the word limited or private limited. Company will also file this order of CG to the registrar for the registration. After revocation of license, CG may order what? CG will order winding up or amalgamation with other company which is having similar object, only in case where there is a public interest. Yes, yes. But before making all these orders, you have to give an opportunity for company to be heard. In case of wind up, after all the liabilities has been paid, if there is some asset, either this will be transferred to the other company, or this will be sold and the proceeds will be transferred to insolvency and bankruptcy fund under section 224. In 224 of insolvency and bankruptcy code of IBC, insolvency of IBC 2016. Solvency and Bankruptcy Code 2016. Next, sections 8 has been contravened. Minimum, how much is the fine? So this is fine. Minimum, how much is the fine? 10 lakhs, maximum 1 crore. And director and officer in default, what is the fine? Minimum 25,000, maximum 25 lakhs. And affairs of the companies have been done fraudulently, then officer default will be liable under section 447 fraud section. Yes or no? Yes. So like this, we have completed section 8. Yes. Yes. Do revise. Thank you. Sir, enjoy your life, sir. So through the link given below, you can get this. You'll be getting this website. This is my website. And if you go through the courses, if you click the courses, CA Intercorporate and Other Law. This one is in English only. If you can see, one is in English only. Next is in Tamil and English mix. Okay. So which one are you gonna select? Either English only, the language, or English and Tamil mix. By clicking this, now let's say I'm choosing English only. Now, the mode, let's say Google Drive. I have chosen Google Drive, and exam is for November 2023. Exam is for November 2023. The price is 699 rupees. The price is 699 rupees. Through this, you can purchase it. Let's say I want for May 2024. It is 999 rupees. But If you want pen drive, and you are choosing November 2023, it is 1,499 rupees. But if you want for May 2024, it is 1,799 rupees. And my recommendation is go for a pen drive, because there are topics which you have to download. My recommendation is go for a pen drive. That is much better. This is how you have to purchase it. This is how you have to purchase it. Okay. Okay. This is how you have to purchase my classes. Now, if you see the books, click on books. There are two things. One is my main book. Next is my summary book. Even if you click main book, let's say you're clicking the main book, you're getting three options. One is Google Drive pen drive. Next is language. You want whether English language or you want English and Tamil, where I'll be explaining you in Tamil language, or you want the exams. Let's say November 2023. You can either select it from the courses if you want my classes, or you can either select it from the book. Anyway, you'll be getting this regular book and you'll be getting the classes. Let's say you have chosen Google Drive. The price is 699 rupees. This is how you will select you can buy my course. Let's say you want, along with this main book, you want my summary book. So you are clicking my summary book, where you see it is 899 rupees. It is 899 rupees. This helps. I have made so that it is easy and better understanding, and yeah, it contains flowchart, bullet points, so that it is very easy for you to remember and present your paper in your examination. So, thank you.